do a better time management. That's all we want you to do.
Please start. Please, please.
Greetings to the bench. I am counsel number 1 appearing on behalf of the petitioners in the matter of Center for Clean Energy and Mitigation of Effects of Climate Change and another.
Mike's will check out. Better.
Am I audible?
Yes.
In the matter of Center for Clean Energy and Mitigation of Effects of Climate Change and another versus Union of Bernicia, Department of Energy and others. The council seeks permission to refer to the bench as your lordships.
Please.
Much obliged, your lordships.
Your Honor is better.
Yeah, no, it's okay.
Your Honor is better.
Leave lordship.
Much obliged, Your Honor. Your Honor, over the next 18 minutes, the Council shall be addressing issue number 1, which concerns with the maintainability of the present public interest litigation filed under Article 32, and issue number 2, which concerns with the maintainability of writ of Mandamus. And in the following 24 minutes, my co-counsel shall be addressing issue number 3 and issue number 4. We respectfully reserve 3 minutes for rebuttals subject to the convenience of the court. If Your Honor are well versed with the
Wouldn't
facts,
it have served better time management had you taken Mandamus and the other person taking Certiorari? Wouldn't it be better time management?
Your Lordship, my
Because
co-counsel.
the biggest challenges the court face today is time management.
Yes, Your Lordship.
Please.
Your Lordship, my co-counsel would be addressing writ of certiorari and I would be addressing writ of Mandamus.
Okay, fine.
Much
That
obliged.
to me makes a
Please
better
go ahead. You need
division
not
of
ask
labor.
permission
Yeah.
for everything. Go
Much
ahead.
obliged.
Please.
If your lordships are well versed with the facts, the council seeks permission to proceed with issues.
Please.
Much obliged. Your lordship, issue 1 concerns with the maintainability of the public interest litigation. Your lordship, in the case of SP Gupta versus Union of India, it has been held that whenever a determinate class of persons are suffering a legal injury and are unable to approach the court due to practical inability, any public spirited person who is acting bona fide and in public interest may maintain a petition on their behalf. Your lordship, in the present case, the petitioners consisting of 7,500 small marginal farmers and with more 12,500 farmers seeking interest in establishing these biomass gasification plants, they are suffering a direct legal injury because, firstly, they are being denied subsidy parity. Secondly, they are being excluded from the state's carbon credit framework due to the 100 kilowatt per hour threshold. Thirdly, there is no assured power procurement from these biomass farmers. Your lordship, so petitioner number 2, Mr. Sesha Ramaswamy, through his NGO, has raised a petition on their behalf. If your lordship may refer to Moot proposition para number 5.
Go ahead.
Your,
please.
Go ahead. Yeah.
much obliged. Your lordship, in para number 5, it is clearly stated that Mr. Sesha Ramaswamy, being a justice delivery professional and working towards clean energy commitments of the state to reduce greenhouse gas emissions, and through his work, there has been a considerable improvement in the lives of people in Prakrit Naidu, and after raising several representations before the state, he has maintained a public interest litigation before this honorable court. Your lordship, the council humbly submits that the petitioners have requisite locus standi. May I proceed with my second?
What is farmers' interest here?
Your lordship, here the farmers have been violated of fundamental rights. So petitioner number 2 have raised a PIL on their behalf because these farmers, they consist of small dispersed households who are based in state of Prakrit Naidu.
No, but farmers' interest here is all about the energy which is getting produced through the residuary or waste. So there is no direct interest of the farmers getting violated here. After all, they are not cultivating something so that they can earn money from the waste. Biomass is based on waste. So what is farmers' interest here?
Yes, your lordship, I understand your concerns. Firstly, the farmers' interest lies in the subsidy policy framed by the state. The subsidy policy, if your lordship may refer to para number 7, last 2 lines of Moot
So
proposition.
do you mean to say that they decided on agricultural pattern based on subsidy plan?
Your lordship, the state has maintained a policy of subsidy that did not give them
that is separate. Do you mean to say that the farmers, they decided to go for an agricultural plan based on the subsidy of the government?
No, your lordship, but when the state is framing a policy, its policy should be such that it considers all renewable producers rather than favoring some of the producers. Your lordship, yes, your lordship.
Is there a legal right to subsidy?
Your lordship, subsidy is a discretionary right as it has been.
No. I'm not. I'm asking whether there is a legal right.
Your lordship.
When you say it is a discretionary right, what is the difference?
Your lordship, I understand your concern. Subsidy is not a legal right per se because it's a discretionary.
If it is not a legal right, how will you be entitled for mandamus?
Your lordship, but whenever there is a policy and that policy is arbitrary, capricious, or malafide, judicial review is there, and the honorable court can exercise judicial review.
I'm not. Please, let's understand the question.
Yes, your
I'm
lordship.
not disputing the fact
Yes,
that
your
the
lordship.
policy can be judicially reviewed.
Yes, your lordship.
All what I'm trying to ask you is there a legal right to subsidy under law?
Your lordship.
If it is a right, which statute gives me? If it is not even a statutory right, you can still go and say that it is a fundamental right. Now, my concern is there a legal right to subsidy in a welfare state? That's my only question.
Your lordship, there is no legal right for subsidy, but when the state is providing a subsidy to certain class of people and excluding certain class of people, then their right becomes considerable, because if the state decide to frame a policy and gives some clean energy producers more subsidy and other clean energy producers less subsidy, then it becomes under constitutional mandate that the policy should be under Article 14 and other fundamental rights.
Then you mean to say that it can't be discriminatory?
Your lordship, the policies can't be discriminatory because it has been held in the various cases of Supreme Court and held by
Continue,
honorable
please,
bench.
please continue.
Yes, your lordship, much obliged. Your lordship, so the
Your honor is better.
Your honor, coming back to my arguments, it is humbly submitted that the petitioners have a requisite locus standi. Now I proceed with my second limb of the argument. Multiple or alternative reliefs may be sought under one single writ petition if they are arising from the same cause of action. Your lordship, had the petitioners have asked for multiple writs such as writ of mandamus, certiorari, and declaration, but they are all arising from the same cause of action, which is the systemic exclusion of these biomass energy
I mean,
producers.
just violation of Article 14, that's all. You don't even say that you have a right, actually. Some
Yes,
class of people who produce electricity get a subsidy.
Yes,
I don't get it to the same one. Fair enough. I think the arguments are made.
Carry on.
You can carry on. Yeah.
Yes, Your Honor. Continuing with my argument, the multiple or alternative reliefs may be sought under one single writ petition, and because these are all arising from the same cause of action, which is the systemic exclusion of biomass producers from the state's renewable energy framework. Now, I would like to proceed with my issue 2 that concerns with the maintainability of the writ of mandamus.
Hello.
If your lordship may please, may I start with my arguments?
Please.
Your lordship, your honor, writ of mandamus compels a public authority to perform their public duty when there is a subsisting right with the petitioner and a corresponding public duty that has remained underperformed as held in the case of Union of India versus SB Vora. Your lordship, your honor, if you may refer to para numbers 8 of the Moot proposition, the Prakrit Naidu Electricity Board, who procures electricity and distribute it. If you're, are your lordship with me?
Yeah, please
Yes,
go ahead.
we are
Please.
with you.
And Union Ministry of Rural Development and Non-Conventional Energy are charged in fixing of subsidy and its disbursement. These are clearly public authorities who are utilizing public resources and framing policies. So these public authorities come under the scrutiny of constitutional mandate. Hence, writ of mandamus is maintainable. Proceeding with my second limb of the argument, the impugned policy is violated.
Is there any public duty to come up with a policy on subsidy?
Your honor, there is a public duty that whenever the state is performing its functions and in a policy, the policy should be framed in.
Mandamus applies only when there is a public duty involved.
Your Honor,
And
yes.
when the state fails to do it, there's no public duty to come up with a subsidy policy, isn't it?
Your Honor, but there is a public duty when the state is framing its policy and it's impacting the rights of the people.
Counsel, you are appearing for the petitioner.
Yes, sir.
There are 5 respondents there. Which among the respondents against whom you are seeking the writ of mandamus?
Against all of the respondents.
All of the respondents.
Yes, sir. May I proceed?
Yes, please.
Coming to my second limb of the argument, which concerns with the impugned policy is violative of Article 14 of the Constitution. Your Honor, classification
But
is...
you know, I'm sorry, respondent number 5, statutory electricity boards of Baranesia. Each one of them will have a different view. So therefore, I think only Department of Energy and the CER, that is Central Electricity Regulatory Commission, it is they who have the statutory duty. State electricity boards do not have it. No, I want you to appreciate. You can't ask for the writ of mandamus against all the 5. You
Not all the
understand?
5 have framed the policy, no? The respondents.
Whoever has framed the policy, only that person you can ask for it.
Go ahead.
Anyway, go ahead. Yeah.
Much obliged, Your Honor. Your Honor, proceeding with my argument under Article 14, classification is valid if it rests on a reasonable basis, and there are 2 tests that have been laid by Honorable Court in the case of DS Nakara versus Union of India. There must be an intelligible differentia that the basis of classification must be clear and understandable. Secondly, there must be a rational nexus to the object sought to be achieved, which means that the classification should have a logical connection to the object that the state is trying to achieve. Your Honor, in the present case, solar, wind and biomass, they are all part of the state's renewable energy framework, and when this, if your lordship may refer to para 7 of the Moot proposition, are Your Honor with me?
Yes.
Last 2 lines, it clearly states that solar and wind producers, they are receiving 25 to 40% of subsidy, which is including civil works. Whereas these biomass producers, they are receiving 10 to 15% of subsidy, excluding civil work. Also, there are 12,500 households that are interested in establishing this biomass gasification plant. But because of lack of timely disbursement of subsidy, they could not do so. Your Honor, when the state is framing its policies, it should consider all the renewable sources because they are equally contributing to the clean energy framework and helping the state to fulfill its international commitments.
No, but clubbing all the sources together under one umbrella of renewable is one issue. There are factors which are creating a sort of distinction amongst all, isn't it? Reliability, technology, availability of raw materials. And that's the reason the state is very correct in having differential policy. Because it's all about also getting a reliable electricity. No? It's also about having a technology.
So if that is the case, then there may be intelligible differentia, in which case you have to look at the other limb of Article 14, which is arbitrariness. You have to show that it's arbitrary, if you can try that, because reasonable classification may not help to.
Much obliged, Your Honor. Your Honor, I would like to point on the fact that these biomass producers, they are small, localized and using the local products by generating electricity and is helping the state fulfill its international commitment and its national commitments of promoting clean renewable energy. Because biomass source also helps in waste management, because these residues that are being used would left outside and would do stubble burning, and these producers also generating local income because they are also part of the economy, these rural households. And if we consider 7,500 households have already established these plants, they are producing electricity on thousands of numbers, and moreover 12,500 have also expressed interest, so they would produce thousands of clean energy production. And I would like to point out the fact that the state's objective is to promote clean energy framework, and when the objective is such, the policy should reflect on its commitments and should promote these localized biomass generation also.
Possibly that is the reason they are not left out. But telling that all of them, they have to be treated on the same platform or same footing, then the state would not be really looking at the local ground or local reality and then everything will be very mechanical.
Just one more to add to my friend's observation. Clean energy framework is the object. Okay. So it's not their object to help small producers. So from the viewpoint of this object, how do you say the classification is irrational or that there's arbitrariness? I can't say anything.
Your Honor, these farmers, they are also part of the economy. Being a rural household and operating on a smaller level, they also deserve a parity with other clean energy producers. And considering these farmers help in clean energy production, and 1 unit of clean electricity produced by them displaces the same amount of clean energy that other producers are producing. And because the actions of the state fails the test of reasonable classification, it operates in a manifestly arbitrary and capricious manner.
No. On the contrary, the state is really looking into balancing the food security and energy security. But after all, the state also has to see that everyone should not get into cultivating those kind of crops. Otherwise, there will be a big challenge with food security. That's why the lesser subsidy is in favoring the Article 14.
Your Honor, administrative convenience cannot be used as a ground to mandate a policy that is clearly arbitrary and operate in an unreasonable manner.
You have not shown it's arbitrary. It's shown that it's arbitrary. How do you say it's arbitrary?
Your Honor,
Your answer is that it's not supporting the small farmers. Every policy need not support small farmers. Yeah, please go ahead.
Your Honor, I am proceeding with my arguments of arbitrariness because it is failing the test of reasonable classification, and it operates in a manifestly arbitrary manner because firstly, these farmers, as already stated by the council, are being excluded because of the civil work subsidy they are not getting. Secondly, there is a threshold of 100 kilowatt per hour being imposed on them, and the state relies on expensive thermal power purchases, often buying at 18 to 22 per unit. There is if your lordship may refer to Moot Prop para number 9.
Yeah, go ahead. Yeah.
Are you
go
Honor with me?
Yeah, please.
There is a possibility when the state deal with these thermal producers of illegal gratification and political bureaucracy. And the facts clearly state that when the state deal with these biomass producers, there is no possibility as such, and it reduces the small producers' ability to increase their quantum of sales. If your lordship may refer to para 9.
Is there any data you analyzed on the basis of that you are arguing this?
Your Honor,
This is simply a blame.
Your Honor, in para 9, it is clearly stated that there is an illegal gratification when the state deals with these thermal producers.
But sometimes it is a feasibility on the basis of that the government is buying electricity.
Your Honor, I understand
It is related to transmission cost.
Your Honor, I understand there might be a feasibility, but when the state, if it decides to promote these biomass producers, they'll also be able to produce electricity on a much larger basis and can replace these thermal power producers in future, because the state is relying on costlier alternatives when there are cheaper alternatives available, which in the current case is biomass production. And because biomass production is helping in the states to meet its overall electricity demand, which is occurred between 7 p.m. to 11 a.m. So it clearly shows that these producers, they are reliable.
Costlier and cheaper also has to be evaluated on the basis of reliability. Quality and reliability is very important for energy access. So thermal may be costlier, but it is reliable. Industry would not accept a source where there would be no reliability of supply. So all these are valid reasons for the state to distinguish and differentiate.
Your Honor, I understand your concerns, but considering the state is transitioning towards a renewable energy segment, and considering it's still importing such expensive imported coal and relying on thermal, the state has the capacity to support these small biomass
It's not 100% imported coal, based on 100% imported coal. My best of my knowledge. Basically, we are utilizing our natural resources. That's cost effective as well sometimes.
If your Honor may refer to para 8.
1 minute, sorry.
Yes.
My brother asked you a question whether you are relying on any external data or merely on. Do you have any other
Case
external
law.
data?
Your Honor, currently we are referring to the proposition.
Oh, please go ahead.
Okay.
If your Honor.
Okay, one question.
Yes, Your Honor.
Since there is a lot of talk about
Yes,
data,
Your Honor.
what is the approximate monetary value of one carbon credit today?
It's
We are talking about of course, I mean, you didn't argue that, the people must purchase power during the entire demand session, not just during the peak. All that is there. That's one point which you didn't sufficiently argue. But I think that your co-counsel hopefully will take up. Now, I'm asking a simple question. What is the monetary value of a single carbon credit today?
Your Honor, carbon credit is the council seeks an extension of 2 minutes to answer.
Yeah, go ahead.
Much
I
obliged.
asked you the question, we'll exempt it. But answer to the question. What is the value of a carbon credit? How is it determined?
Your Honor, carbon credit is a tradable instrument which is given when there is a clean energy production and it replaces 1 metric ton of carbon.
Like a share, it has a value, right?
Yes.
What is the value today?
The council is aware that when it displaces 1 metric ton of carbon, then carbon credit is issued.
I don't know what the council is aware. But I'm not
You
being
don't
made
know-
aware
You
of
don't
what
know,
is the
say you
exact
don't know
monetary
nothing wrong.
value.
Yeah. You need not know everything. Go ahead.
Your Honor, the council is currently not aware of such.
That is better, isn't it? Rather than okay, go on. I think the time allotted to you is over. Hopefully, you will have a right.
You
of
have 1
rebuttal.
minute. One more minute.
And,
You can have.
yeah?
One more minute.
Your Honor, coming back to my argument, the council, it is humbly submitted that the impugned policy is violative of Article 14 as it fails the reasonable classification test and manifestly arbitrary. I conclude my submission here, and it was an honor
Thank you.
arguing before the court. Now I yield my floor open to my co-counsel to present their arguments. Much obliged.
Please.
Appearing on behalf of the petitioners. In the next 24 minutes, I shall be dealing with issue 3 that pertains to the writ of certiorari and issue 4 that pertains to the writ of declaration. With your Honor's due permission, may I proceed with issue 3?
Please.
Much obliged, Your Honor. Issue 3 concerns the validity of the circular that imposes a restriction, a threshold of 100 kilowatts per hour on clean energy producers to be able to monetize the carbon credits that they're earning by producing clean energy. It is a respectful submission of the petitioners that this circular is unconstitutional and liable to be quashed by the Honorable Court. I will advance my submissions under the following heads. Firstly, the writ of certiorari is maintainable in the present case. Secondly, the capacity-based generation, the capacity-based differentiation in this case, it is violating Article 14 of the Constitution. And thirdly, the inability to monetize the earned carbon credits of these producers, it is violating Article 21 of the Constitution.
What is the first one? Sorry.
That the writ of certiorari in this case, it is maintainable. Your Honor, a writ of certiorari lies where an authority acts without jurisdiction, in excess of jurisdiction, or in violation of law or fundamental rights. Although the ambit of certiorari earlier was only restricted to judicial or quasi-judicial acts, now it has been expanded to also include administrative actions or any action that relates to public duty, Your Honor. Your Honor, in this particular case,
What is this action? Is it administrative action or executive action?
Your Honor, this is not an administrative action because
I'm sorry. It's not an administrative action. It involves application of mind. Okay, it is an executive action.
Your Honor, the council said that only that it is not an administrative action because if it would be an administrative circular, it would not be binding on everybody.
No, I'm sorry. It is not administrative.
Yes, Your Honor, I agree
Yeah.
with you.
It is actually. Carry on.
Yeah.
Much obliged, Your Honor. Your Honor, the impugned circular, it is not a mere internal guideline. It is imposing restrictions on the monetization of these carbon credits that the small-scale producers have earned, and therefore it is impacting the economic rights and livelihood of these producers, Your Honor.
No, sorry. It actually doesn't benefit the farmer. It only benefits the NGO. They are getting less than 100 kilo. Most of them are not producing. They are producing just 10 kilowatt per hour. This is available only for those who produce 100 kilowatt.
Yes,
So
Your
it
Honor.
is not really for the benefit of the farmer. It
Yes.
is for the benefit of the NGO, which is going to have all these rights assigned. So I don't think, we have the rights of the farmers involved here actually.
Your Honor, the council's contention is that because there is a threshold of 100 kilowatt per hours, so the small scale producers who are not able to monetize their earned carbon credits, it is violating their rights, Your Honor.
Carry on.
Your Honor, being a regulatory instrument issued by a statutory authority and operating unconstitutionally, it squarely falls within the ambit of certiorari jurisdiction. Your Honor, therefore, it is humbly submitted that the writ of certiorari is maintainable in this case. Your Honor, moving to my next submission under Article 14 of the Constitution,
Please.
as argued earlier by my co-counsel, for there to be a reasonable classification under Article 14, there needs to be an intelligible differentia and rational nexus with the object that the state is trying to achieve. Your Honor, in this case, there is no intelligible differentia or rational nexus. Your Honor, if you may please refer to Moot proposition, paragraph 7, line 7 and 8. Your Honor with me? Your Honor, from these two lines, we can clearly infer that the only differentiation that they have made for this classification is generation capacity. Whether a producer is operating 100 kilowatt above 100 kilowatt per hour or below 100 kilowatt per hour. But Your Honor, in the present case, the environmental benefit that we derive from this clean energy production, it is not based on the size of the generator. Each unit of clean electricity or clean energy that is produced, it is displacing an equivalent unit of polluting energy, regardless of whether it is from a nano 10 kilowatt per hour generator or a large scale commercial installation. Therefore, capacity by itself, Your Honor, it does not classify as an intelligible differentia. Even if we assume that it does classify as an intelligible differentia, there is no rational nexus with the object sought to be achieved. In this particular scenario, the stated object of the carbon credit framework, it is to promote clean energy and incentivize the reductions in greenhouse gas emissions that is happening. However, if we exclude these small scale producers, Your Honor, it is not really furthering the object of this scheme.
This
On the contrary,
carbon credit gets regulated under which law?
Your Honor, in the Union of Bernicia, Energy Conservation Amendment Act 2022 and the Carbon Credit Trading Scheme 2023, under those frameworks, the carbon credits framework is there.
Okay, so in going by that framework, there is a clear guideline that why monetization shall be allowed only to those who are sustainable player. Because after all, it's a market driven thing. So you cannot allow everyone to be part of the market mechanism. Otherwise, there will be no sustainability in the model. And that's why it is very much valid.
I understand your concern, Your Lordship, Your Honor, but in the framework that the Council just mentioned, the Energy Conservation Act and the Carbon Trading Scheme, there is no such restriction or reasons given as to why this threshold could be valid. In the Union of India, not Union of Bernicia, where these schemes are there, there is no such threshold given in these schemes itself, Your Honor.
Carry on.
Much obliged, Your Honor. Your Honor, on the contrary, if this threshold is there, it is discouraging these decentralized small-scale farmers to generate their electricity. It's instead of incentivizing clean energy, which is the object of the scheme, it is selectively rewarding scale, which is not the object of the scheme, Your Honor. Such a classification, therefore, it has no rational nexus to the object of climate mitigation and clean energy promotion. Your Honor, the respondents might seek to justify this restriction based on administrative convenience or ease of monitoring. They might say that because these are decentralized units, the monitoring cost for the administration will be high, it will be difficult to administer. However, for this, Your Honor, if you may please
They
refer.
are not citing such reasons. They are citing technical reasons, reliability of power, etc. So, yeah.
Yes, Your Honor. Even if we consider their argument for technical reasons, Your Honor, regardless of whatever the intention of the state was while making the law, or whatever the intention of the lawmaker was while making a particular law, if its effects or consequences of that law, if it is violating or infringing upon fundamental rights, it is unconstitutional, Your Honor.
No,
Your
this
Honor.
is not about intention. This is all about the technology available and accordingly making the plan.
Your Honor, if you may please refer to page 11 of the compendium, petitioner's compendium.
Okay, please proceed.
The case of Bennett Coleman versus Union of India. Are Your Honor with me?
Yeah, please proceed.
Your Honor, the highlighted part of the paragraph from the bottom, if I may read.
Please read.
The object of the law or executive action is irrelevant when it establishes the petitioner's contention about infringement of fundamental rights. Your Honor, the respondent's submissions under technical problems or measurability or verifiability of the carbon credit, Your Honor, all of these objects or the arguments that they're claiming, those are not valid arguments if they are infringing upon the fundamental rights of the of the citizens, Your Honor. In this case, even if they're applying a threshold of 100 kilowatt per hour, the state might have valid reasons according to them to impose this threshold. But if it is violating the fundamental rights, according to the case of Bennett Coleman versus Union of India, it is not constitutional, Your Honor.
Is there any right available to these farmers to trade on energy?
Your Honor, could you repeat your question?
Is there any right available to farmers to engage into this trade?
Yeah, Your Honor, in this case, the farmers who are producing above 100 kilowatt per hour, they can trade their carbon credits, Your Honor. But because of the circular, the small scale producers in this case, they are not able to monetize.
Carry on.
Your Honor, if you may refer to compendium page 11, page 12, Your Honor, apologies. The case of Modern Dental College and Research Center versus State of Madhya Pradesh. Your Honor, this case clearly states that even if a restriction it is imposed in public interest, it must satisfy the test of proportionality. In this test, Your Honor, for a restriction to be reasonable, it needs to pursue a legitimate aim. It is necessary to achieve that aim, and it is the least restrictive alternative that is available. But Your Honor, in this case, there are more less restrictive alternatives available, like pool trading mechanisms or intermediary based verification systems. So, Your Honor, because there are more less restrictive alternatives available, it is also not a reasonable restriction as it is not satisfying the proportionality test, Your Honor.
What do you know about European green energy tariff system? Have you heard anything about it?
Your Honor, the Council is not aware in detail of the same.
I
Apologies.
think it would have given lots more strength to your argument. European Economic Community nowadays imposes a tax on imports. If the imports are made by an unclean energy, thermal energy, they pay taxes. If the imports are made by clean energy, bioenergy and all that, there is no tax. So, I think you will be better off to do some research on European Energy Tariff Act. Anyway, I think, yeah.
Apologies, Your Honor. I will look into this for sure.
Sure.
Your Honor, moving to my submission under Article 21 of the Constitution. Your Honor,
Any authority on which in which proportionality test has been applied in reference of Article 19?
Your Honor, in the case of Modern Dental College and Research Center versus State of Madhya Pradesh, it was in this case, the facts were as such that it was applied in under Article 19(1)(g) itself, Your Honor. Right to trade only it was applied. And the state had held that the restrictions that were imposed on the college itself, they passed the proportionality test, and it was therefore the Supreme Court held it as valid.
Okay.
Your Honor, Article 21, it guarantees that no person shall be deprived of life or liberty except according to procedure established by law. The word life under Article 21, it has been expanded to include the right to livelihood as well. Accordingly, if any state action is violating the right to livelihood of a person, then it violates Article 21 of the person as well. In the present case, the biomass gasification units, they generate clean energy or renewable energy. This generation of renewable energy, it translates into carbon credits, Your Honor. These carbon credits, they are recognized as tradable instruments under our domestic law.
So
And
a state cannot withdraw this policy in its entirety tomorrow because it's connected with right to livelihood.
Your Honor, the policy in this particular scenario of carbon credits, it is
Your point is well taken by the bench, but as you are connecting it with livelihood, can tomorrow a state completely withdraw the policy? And then can someone come to the court saying that you are violating my right to livelihood? Is it possible?
Your Honor, in this case, if the court completely takes away this policy, it would be taken away for everybody in the Union
No,
of
but then it
Odisha.
is right to livelihood.
But Your Honor, it would pass the Article 14 test. So Your Honor,
No, but it would violate 21.
Your Honor, if I may explain this from the perspective of Maneka Gandhi versus Union of India, in this case, it was held that the golden triangle concept, that Article 14, 19, and 21 should be read together, and for there to be a restriction on any of them, it should pass the tests for all the three of them. So, in this case, Your Honor, if the policy would be taken away, it would be under the exception of procedure established by law under Article 21, because it would pass the reasonable classification test under 14, as it would be equal for everybody in the union and not only a particular set of people.
Let me ask you, when you're talking about, my brother referred to the fact that the livelihood of farmers does not depend on selling of power generated from agricultural waste. Livelihood is dependent on agriculture. So how are you linking this to livelihood?
Your Honor, because other similarly situated clean energy
So therefore you
producers.
are on 14, not on livelihood.
Your Honor, could you
You
please?
are on 14, discrimination, not on livelihood. That's my observation. You are free to go ahead and rely on you.
Carry on.
Much obliged, Your Honor. Your Honor, because these carbon credits, they are recognized as tradable instruments in our domestic law. The small scale farmers, they also have a right to monetize these carbon credits. But however, because of the impugned circular, they are not able to claim this right, Your Honor. Therefore, this restriction, it is not merely regulating the manner of earning income. It is extinguishing an entire source of livelihood which is available to other similarly situated producers. Therefore, it violates Article 21. Further, Your Honor, as I was claiming, under Article 21 there is an exception to deprive somebody of their life or livelihood, that is procedure established by law. But for the state action to fall
No,
under
no,
this
Article
exception,
21 relates to personal liberty.
yes, Your Honor.
No, procedure established by law, all that is fine. I mean, same applies. I would be willing to buy your argument under Article 14, violation of Article 14. But it is difficult for me to accept the applicability of Article 21, which relates more to personal liberty. Well, I mean, it's how does it reconcile that? How will you say your right to life is violated? People can live without power, can they not? Didn't our forefathers live like that?
Your Honor, just because they have another source of livelihood does not mean that the state has the right to take away one of their sources of livelihood, Your Honor.
Carry on. Carry on.
Much obliged, Your Honor. Your Honor, as it does not satisfy the Article 14 test, it is also not a valid restriction under the exception of procedure established by law, as given in the case of Maneka Gandhi, Your Honor.
Just want to say that you need not be very anxious about time. Even if you have not completed, we will not hold it against you because we are firing a lot of questions.
Yes.
So go ahead. Yeah.
Much obliged, Your Honor. Your Honor, with your due permission, may I proceed with my next issue?
Go ahead, please.
Much obliged. Issue 4, it concerns whether this Honorable Court ought to issue a writ of declaration that all biomass energy producers, they should be at parity with other clean energy producers. Your Honor, the petitioners respectfully submit that the state's differential treatment of these biomass producers, it is contrary to the directives principles of state policy and the international climate obligations of the Union of Bernicia. Your Honor, while the directive principles, they are non-justiciable, but they are very fundamental to the governance of the state and they must guide state policy. Article 38(2), it mandates that the state shall strive to minimize inequalities in income, status, facilities, opportunities, and etc. While Article 39(b), it directs the state to distribute the material resources of the community so as to subserve the common good. Your Honor, reading these two articles together, in the present case, renewable energy incentives, grid access, and carbon credit markets, they constitute material resources and economic opportunities in the context of the DPSPs, Your Honor. So if we exclude these small-scale producers from subsidy parity and carbon credit monetization, the state is conferring these rights to only dominant sectors that is there in the renewable energy framework, rather than following the concept of equality that we can take from these DPSPs, Your Honor. Moreover, Your Honor, biomass units, They also help with the big problem of pollution that we have in our union. As we know, pollution is a prevalent problem in the union of Bernicia, and these biomass units, they are taking this agricultural waste or even animal waste, and with that they are producing the clean energy. So, and also, Your Honor, they're reducing stubble burning, because if this agricultural waste would to be left like that, it would go into stubble burning, causing a lot of carbon dioxide and monoxide emissions, Your Honor.
How
So,
do you characterize sources of renewable energy as material resource under Article 39?
Your Honor, uh,
From where this creative argument coming?
Your Honor, if we read Article 38.2 and 39b together, because 38.2 it mandates equality in the sense of opportunities. So here the opportunity to be able to monetize their carbon credits, Your Honor, it
No,
should
the
be
bench
equal.
is keen to understand that how are you reading the sources which are required for generating renewable coming under the understanding of material resources?
Your Honor, in this case, the material resources that is there, it could also be the subsidy or the rights of the carbon credit framework, Your Honor. So the subsidy carbon credit framework, it should be equal, not arbitrary, Your Honor.
Okay.
All right.
Your Honor, hence, because of the also pros of biomass units, that all the profits that they have, that they reduce stubble burning, they utilize agricultural waste, denying them meaningful market participation, it does not advance the common good, Your Honor. Rather, it undermines inclusive and sustainable development. Your Honor,
Where
moving.
does common good come in? Common good is not a legal, I mean, it may be a legal, but in this context,
Your Honor, this was under the context of Article 39b, that
Oh.
the material resources should be for
Okay,
the
go
common
ahead.
good. Your Honor, moving ahead to my submission under international obligations of the Union. Under the settled principles of Pacta Sunt Servanda, the obligations that the Union has, they should be completed in good faith. This commitment finds constitutional hold in Article 51c of our Constitution, that mandates respect for international treaties and obligations, Your Honor. Having ratified the climate protocol, like the Paris Agreement and Kyoto Protocol, the state, it is expected to structure its energy incentives consistently with low emission developments. Your Honor, Article 2, subclause 1 of the Paris Agreement, and Article 6, subclause 8 of the Paris
So going
Agreement.
by your argument, it seems that the state shall not come up with any policy on subsidy or otherwise unless and until entire wherewithal is managed by the state. Then in that case, we would be violating international commitment. No, at least at this stage, it is a case of incremental implementation. State is gradually moving towards that direction. You are arguing that declare everything unconstitutional. Then in that case, we would not be complying with the international commitment.
Your Honor, I understand your concern, and to address that, the Union of Bernicia, because it has signed these protocols and agreements, it has commitments that it needs to produce a certain amount of renewable energy by years like 2030 and 2070, Your Honor. In this case, if you look, the biomass producers that are affiliated with the NGO only in the state of Prakrit Nadu, they are already 7,500 in number, Your Honor. Even if you assume for the sake of it that they're producing the minimum quantity that is allotted to them, that is 10 kilowatt per hour, it would still at a national level be 75,000 if we culminate them.
That is for the state to judge. We can't judge. We can't really get into this, shoes of the executive and
we don't
decide on
even
that.
have that expertise. We don't, yeah.
And at the same time, you are also not giving data to us.
I understand your concern, Your Honor. The council is just trying to point to the fact that in this case, 7,500 they are affiliated with the NGO. More 12,500 they are showing interest. This alone is only in the state of Prakrit Nadu. If you look at these small scale producers at the level of the union, there are so many more that are not even mentioned here that are producing energy below 100 kilowatt per hour. But because of this impugned circular, they are not able to monetize the carbon credits, Your
Let me
Honor.
ask you one legal question. You are relying substantially on Article 38, 39, 51C, which are all part of Part 4.
Yes,
under,
Your
under Article 37, they are not judicially enforceable.
Yes, Your Honor.
So how can we enforce them?
Your Honor, the council's contention is not that these are binding, the international obligations. Your Honor, due to paucity of time, the council seeks an extension of 2 minutes.
Yes, go ahead.
Much obliged, Your Honor. The council's contention is not that these international obligations or the DPSP are binding. The council is stating that there are violations of fundamental rights like 14 and 21 and moreover 19 as well, Your Honor. Adding on to this,
Counsel, I'll ask you a basic question. You talked about different types of energy,
yes, Your Honor.
and you talked about different gradations of the energy being clean, right? Which is the cleanest energy? Which is the dirtiest energy?
Your Honor, in the framework of the clean energy framework in the Union of Bernicia right now, the carbon credits that are allotted, it is depending on.
No, you have hydel energy, you have thermal energy, you have solar energy, you have ocean thermal energy. These are the different types of
Yes, Your Honor,
energies which
yes.
are available to a grid. Which is the cleanest? Which is the dirtiest?
Your Honor, the dirtiest would be thermal energy.
Okay, what is the cleanest?
Your Honor, there are various forms of clean energy.
You can
The
say
council
you
is
don't
not
know, you
aware
don't
of the
know.
cleanest.
Just now I told you the different forms. The question is, what is the cleanest and what is the dirtiest? You
Your
told me dirtiest is thermal.
Yes,
Fair enough. Which is the cleanest?
Your Honor, this lies outside the expertise of the council. The council apologizes, Your Honor.
I mean, I don't know. I'm not too sure. Anyway, never mind. Yeah.
Carry on.
Yeah.
Your Honor, addressing your question, these international obligations or DPSPs, they are not binding on the state. The petitioner does acknowledge that. These are not our main arguments or contentions. What the council is trying to say here is that there are violations of fundamental right. Moreover, they're also not following the DPSP or international obligations, Your Honor.
The
If I
answer
may-
could be that in Ranveer Singh and other Minerva Mills case and other cases, Supreme Court has held that when read with fundamental rights, directive principles of state policy also are enforceable. That may be the answer. Go ahead.
Much obliged.
And again, you're highlighting violation of fundamental right. Instead of that, I think there is a hidden commercial agenda is involved, and you are focusing more on that. Ultimately, it is NGO is the beneficiary of that.
Your Honor, in this
What's
case,
your take on that?
Your Honor, to answer your question, the NGO is not a beneficiary of. It's not getting any.
So who is
monetized-
going to claim this ultimately carbon credit on behalf of all the farmers?
Your Honor, if the impugned framework is quashed by the Honorable Court, then the small farmers would be able to monetize these credits for themselves. Right now, because of the framework, they are not able to monetize these credits. So when they get these credits, it is just left with them like residue. They have no use of it because they cannot monetize it. So the NGO acknowledges the monetary value of these carbon credits, and hence, in return of the carbon credits being vested with the NGO is given technical assistance. So, Your Honor, it is a quid pro quo consideration situation. It's like consideration because the NGO does acknowledge that these credits have monetary value. But whatever the NGO can do, it's in its individual capacity to recognize the monetization of these carbon credits. The NGO is doing so, Your
So
Honor.
public interest vis-a-vis commercial interest involved in this case.
No,
no.
Your Honor, there is no commercial interest of the NGO involved.
You outrightly rejecting that point. There is no commercial interest or a hidden agenda on this.
No, Your Honor, there is no hidden agenda. Even the 1% income that the farmers are given to the NGO, that is voluntary, Your Honor. It is not. It is stated in the Moot proposition that it is voluntary, Your Honor. The NGO is not asking for it.
You can conclude.
Much obliged, Your Honor. Your Honor, just concluding my submission under the international obligations. Because it violates these said articles like Article 6, subclause 8 of the Paris Agreement.
You
It is
did argue on purchase of power during the entire consumption circle rather than during the peak load demand.
Your Honor, I was just about to come to that argument.
Okay.
Your Honor, because Article 2 of the Paris Agreement, it says that the incentives, it should be consistently with low emission development pathways. But in this case, the state is also going to peak purchase hours. It is also purchasing the thermal electricity instead of the clean energy electricity, Your Honor. It is prioritizing coal-based procurement despite cheaper biomass availability. So this is also in violation of the Paris Agreement, Your Honor. Moreover, Article 6.8, it says to promote clean energy. And if we are not incentivizing these small scale producers, then they will be demotivated to promote clean energy because of the incentivization that is there coming with the carbon credits. A lot of like 12,500 they're showing interest, but if this is not given to these small scale producers, then they will also be demotivated to produce this clean energy, your honor, and hence it is at the end not promoting clean energy. Your honor, if the court has no further questions, the council would like
Is
to.
there any obligation for those farmers to come and join this clean energy drive?
No, your honor, it is voluntary.
So per se, then there is no right which is accruing in favor of the farmers, is it?
Your honor, the farmers who are voluntarily choosing to promote produce this clean energy, their rights are being violated. Your honor, if the court has no further questions, the council seeks to conclude with the prayer. Much obliged, your honor. Wherefore, in the light of the issues raised, authorities cited, arguments advanced, and cases referred, it is most humbly prayed and implored before the
You
Honorable
wasted
Supreme.
30 seconds, my friend.
Can you repeat your
I
honor?
said you wasted 30 seconds. Tell us what you want.
Your
You want
honor.
a writ of Mandamus.
Yes, your
You
honor.
want a writ of Certiorari.
Yes,
right?
your honor. Yes. The council humbly.
Time management is very
Yes, Your Honor.
important, you know. Just because your memorial writes all this, you don't have to read it out enough.
Much obliged, your honor. The council humbly seeks that the honorable bench may declare that the PIL in the form of
Allow
the
my
petition.
petition with cost.
Much obliged, your honor.
That should be your prayer. All right, thank you very much. We appreciate your participation.
Much obliged, your honor. It was an honor arguing before the court.
Yes, one observation. There are many cases like Visakha case, Visakha guidelines case, and apparel export promotion, PUCL was Union of India, where Supreme Court has held that international convention obligations are enforceable by Mandamus. Perhaps you could have referred to that. Yeah, go ahead.
Yes, your honor, but it is only with regards to if there is a consistent policy framework in the union as well. And right now there is no such framework, so the council unfortunately couldn't claim that.
All right.
Much obliged, your honor.
Thank you very much, Council. We call upon the next team to.
Can permission be denied?
Please go ahead. And don't seek permission for everything. Make your submission.
Greetings to the bench. It is humble pleasure of the council to argue before the honorable court in the matter of Center for Clean Energy and Mitigation of Effect of Climate Change and others versus Union of Bernicia on behalf of respondent. The council will.
You are arguing on behalf of all the respondents or some other?
Indeed, we are arguing on the behalf of all the respondent. The council will be dealing with the issue number 1 concerning the locus standi of PIL and issue number 2 concerning the violation of Article 14, and will be taking total time of 22 minutes. And my learned co-counsel will be dealing with the issue number 3 concerning violation of Article 19 and issue 4 concerning violation of Article 21, and will be taking 21 minutes of the court's time, and 3 minutes are reserved for the rebuttals. If your honors are well versed with the fact, the council
I
gives
think we
permission.
said it during the beginning of our
Indeed.
commencement of the session. We can't take an exam on our familiarity with the facts, can we?
Go ahead.
Proceeding with the issue number 1, which is the locus standi of the NGO. Your lordship, the NGO does not have the bona fide interest. So the petitioner have claimed the PIL writ petition. However, here there is a commercial interest of the NGO. The council would be proving the same. If your lordships may refer to the page para 7 of the proposition.
Go on.
Is your lordships are with
Yeah,
me?
yeah, go ahead.
Line 5th. So the petitioners have claimed that the NGO is providing technical assistance. However, we need to see that there is a condition. The emphasizes need to be addressed on the condition word. That there is a condition that if the farmers will sell the carbon credit, if the farmers will give the carbon credit, then only the technical assistance will be given. A. And the contention B is that the farmers, if your lordships may refer to the again para 7 line 3, the NGO devised an elaborated network. Basically, whatever the remaining residues are there, it basically gives the high quality silicon and the yield active charcoal. That also to basically sell that the farmers the NGO is maintaining an elaborated network. So both these contention are showing the commercial interest of the NGO.
What's wrong
Also,
with that? What's wrong with that?
Your lordships, if a PIL is claimed, it can't be commercially interested. Also
Why not?
held in
Why
the
not? See, the entire thing is commercial interest of certain companies in the solar and thermal energy, and certain poor producers of through biomass who are too numerous to come together, and so there's an NGO collecting themselves together, and to meet the costs or whatever, they're also charging a fee. There's no law that absolutely commercial interest is barred in
indeed.
PIL.
Your
Profit is
lordship,
not a dirty word in the capitalist society.
your lordship, the council understand the concerns.
Do you mean
However,
that you are not trying to pass any benefits to those who are trying to clean the environment?
your lordships, if addressing the question number one, then proceeding with the question two. Question number one, basically the PIL concept itself. So if a person is filing the PIL, a public spirit is filing the PIL, there should be a bona fide interest. However, the NGO's commercial interests have been shown here. So that's why the PIL itself is not valid, because also held in the Balco Employees Union versus Union of India, if your lordships may refer to the flagging 3 compendium, page 22. Compendiums flagging,
Please proceed.
page number 22. Balco employees case. So the principle, is your lordships with me?
Yes.
The principal public interest litigation was not meant to be weapon to challenge the financial or the commercial decision which are taken by the government in exercise of their administrative power. Hence, it is proof that the PIL can't be used as a tool to challenge the commercial or the economic interest or economic policy of the government per se. So, is it
Where is the government involved in this?
your lordships, the policies which have been framed by the legislature and the implemented by the executive, and the law, Barnesia Energy Law, permits the same.
All right.
Indeed,
No, but who has framed the regulation? Regulatory Commission.
indeed.
A regulatory commission is an independent autonomous body. Where is the government coming in here?
Your lordships, if we are going to so basically, the petitioners have claimed the state's action.
Saying regulatory commission is a state under Article 12 is different issue. Here,
Indeed.
regulatory commission has made this policy, and regulatory commission enjoys independent status. So why are you saying that's a policy decision of the government?
Your lordships, the claims which have been mentioned by the petitioner, that there is an parity, basically there is a discrimination by the government per
That
se.
is their set of argument.
Indeed. So that's what the council is addressing per se. The council agrees on the point of the board's maintainability. So that's why the PIL isn't here. The NGO's commercial interests have been shown. Moving to the issue number 2, which is on the Article 14 violation, which the learned petitioners have been claimed. So, your
In
lordship,
a country like India or Burnesia,
indeed, your lordship,
the state is doing a lot of business.
indeed, your lordship,
There are several listed companies of Union of India operating in the stock market.
indeed.
So many of the electricity boards, respondent number 5 here, they are there to make profit. Or isn't it right?
They are not here to make the profit. If your
I thought supply and distribution of electricity is a business.
the supply and demand principle depends on the if your lordships may refer to the basically the objective of the policy of the energy law. If your lordships may refer to the compendiums,
Addressing people as judges as lordships violate of bar council resolution. So you'll get minus marks.
your lordships, the
Honor.
your honor. Apologies for the
Go
same.
ahead.
Apologies for the same. Your honor, the Article 86 talks about the promotion of the co-generation renewable energy. For the basically the if your lordships are with me, page 11, Article 86 of the energy law. Compendium, page 11. So basically, the motive, the objective of the policy is to promote the renewable energy, and that's what the state is doing. That's what the board is doing. So addressing the question of the honorable, your honors.
Well, I asked you the same question that I asked the other side. What is the cleanest energy? What is the dirtiest energy?
Your
Because I think the lawyers must understand facts first,
indeed, your
Like,
honor.
these are the basic facts, actually.
Your
Or classify different energies for me. Which is cleanest, which is dirtiest?
Your honor, as the renewable energy per se is there isn't basically bigger class. If we are dividing it into the cleaner and dirtier, the cleanest would be renewable and dirtiest would be thermal.
No. This is again too generic,
Indeed.
In renewable energy, there are 4 types of energy. Right? Which energy you are talking about?
So
In renewable energy, hydel energy, is it renewable?
indeed it
It
isn't
is.
renewable.
Okay. Thermal energy, is it renewable?
Indeed.
Huh?
Thermal is not the renewable. Thermal is
In thermal energy, there is coal energy,
Yes,
oil
other
energy,
fuels.
gas energy.
Indeed.
Not all of them have the same clean energy category. Now, I want you to understand, there are different types of energy you are talking about. Which is the cleanest, which is the dirtiest? I am asking a basic
If you
question.
don't know, please say you don't know. If you are sure you know, then tell them.
the council seeks apologies for the same.
Carry on.
So carrying on
You don't
the
have to
article-
apologize for not knowing, provided you
council
will
would
know
be-
and come back again. Okay.
Indeed.
All right.
Council apologizes for the same. Council will research for
Carry
this.
on, please.
So the claim which are that Article 14 have been breached and there is no intelligible differentia and rational nexus. So your honor, Article 14 talks about the equal protection of law and equality before law. However, that does not mean everyone should be treated in absolutely symmetric or the mathematical manner. Your lordships, if your lordships may refer to the page 102 or flagging 22, case of the state of West Bengal versus Anwar Ali Sarkar. Flagging 22.
Yeah,
Please,
fine.
please.
Please
Go ahead. You don't have to.
Your lordships, where it is clearly mentioned that that absolute symmetry is not permitted and reasonable classification is permitted in the Article 14.
But
under the
why are you asking us to apply the ratio of Anwar Ali Sarkar, which is a subject matter related to criminal law, on a subject which is regulatory law? Are you not guiding this court in a different direction? Anwar Ali Sarkar is on a criminal law.
Your lordship,
We are right now talking about regulatory law,
Your-
which is very dynamic, which contextual. So why that ratio should be helpful for us?
Your lordship, the very principle of the Anwar Ali Sarkar, which is basically Article 14, is seen on those principles where it has been mentioned that class legislature and the reasonable classification principle. So that principle is used by the council for the same. And also in many other cases, including the state of Punjab versus Devendra Singh and others, there are again this
But
principle have been reiterated.
ratio is always about fact plus reason.
Indeed, your
We
lordship.
can't ignore fact.
Indeed, your lordship.
Please proceed.
Context is important. Context is important.
Since you represent most of the government agencies, because you are the respondent, appearing for the respondent here, what is the present global status of carbon credit regime?
Your lordship's council is not aware about it.
All right. Carry on.
Apologies for the same. So the claim was that there is no intelligible differentia or the rational nexus. So council is going to prove the same. Your lordship, if your lordship may refer to the proposition page, proposition para 4. So the intelligible differentia would be on the basis of the installment cost of the other, like solar, wind and biomass. The basic claim is biomass and like difference between the solar, wind and biomass. So the intelligible differential is based on the installment cost, which basically differs. Solars is around 6 winds is 6.5 crores and biomass is around 3 crore. So on basis of this, the intelligible differential have been mentioned. Also, we need to see the unit contribution. If your honor can see the chart.
No way we can see that.
Carry on. Carry on.
So basically, there is an installment cost comparison and the unit contribution. So on basis of these two, installment cost are these like 3.3 to 6 and 4 to 6.
You're referring to the data furnished.
Indeed.
Yeah.
Yes,
so
yes.
Indeed. So basically, we have to see both together, and then there is an intelligible differential have been set up. So after that, the rational nexus is there to ultimately promote the
No,
objective.
but what is the purpose of subsidy?
The purpose of subsidy is to promote the renewable energy.
Promote
in
the
this
renewable
case.
energy.
Indeed.
Then in that case, all the sources what you're talking about, even though there's a difference in cost of establishment and all, but ultimately all of them they're contributing to cleaner energy.
Indeed, your
There where they are challenging the intelligible difference here.
Indeed, your lordship.
Then-
So again, it depends on the unit contribution, and also this is an economic issue per se.
These points are very valid.
Indeed.
But ultimately all these are resulting into what? Contributing to cleaner source.
Indeed.
And there where they are saying that if your subsidy is all about cleaner source, treat every source equally.
Your lordship, we have to see other technical grid grievances as well and other grievances as well. Also, by giving very subsidies to the biomass, we are not denying the subsidy, and we are also promoting, as mentioned in 86 Article 86 of the Energy Act 2003, at 86E, where it is clearly mentioned that we have to promote the renewable energy, and by giving very subsidy, we are promoting the same. Also, again, as mentioned earlier, that it depends on the installment cost and other cost as well. So that's why the difference in the subsidy is here. If your lordships are satisfied, the council would be proceeding with the carbon credit framework. Indeed. Much obliged. So there is an intelligible differential on basis of those basis on the generative capacity, those who can generate above 100 kilowatt and those who can generate below 100 kilowatt. So the nexus behind this is that to regulate the credit carbon mechanism. Also, if your lordships may refer to the flagging 28 of the compendium, National Electricity Policy 2005. Is your lordships with me?
Yeah.
Your lordship, the flagging. So basically, there is need to be in cogeneration and non-conventional energy.
What is cogeneration?
Cogeneration is renewable energy.
No.
Your lordship, cogenerations are the other than renewable energy, basically thermal energies or those which depends on the fuel per se.
Tell her what.
Non-conventionals are the are basically clean energies.
Cogeneration is something, let's say, for example, when thermal is getting used, no, with that gas is also getting produced. So that's how you look at it, the cogeneration.
Indeed.
And
Much.
what is the evidentiary value of this policy before this court of law? Why this court should take cognizance of the policy?
Your lordships, because the very subject, like the by the so this policy is governed under the section 3 of the Electricity Act 2003.
Okay,
So
good
because of that, the validity of the policy per se has been established. Your lordship, so in 5.12.1, it is mentioned that the cost of generation or is your lordships with me?
Yeah, go on.
Please
go on.
proceed.
Go ahead.
So cost of energy can also be reduced by promoting competition with such project. And so the basic submission of the council is that we need to see competition of the carbon credit market, and we can't just open it. There need to be a regulation per se.
No, but if you
Also,
exclude somebody totally, how are they going to compete with you?
your lordships, again, that the competition basically motivates the farmers to work more harder. And also, if your lordships may refer to the page 131, where is basically objective of the policy. If your lordships may refer to the page 131, the objective is to ensure financial viability of the sector and to attract investment. So the basic purpose of the capping is to financially stabilize the very mechanism of the electricity and very mechanism of the carbon credit threshold. If your lordships are satisfied, the council would be moving to the issue 3, which is price parity. Your lordships, the councils, so basically this argument is on the twofold. A, that very article, so Article 86 Clause 1, Clause C, or Article 86 of the Electricity Act permits the state commissions to administer as well as regulate. If your lordship may refer to the page 9 again of the
So
compendium.
86 is a legislative function of the regulatory commission, or it is executive function?
Your lordships, it is regulative as well as administrative
The
function.
reason being, depending upon the nature of function, the judicial inquiry shall be made
Indeed.
or the review shall be made. If it's a legislative parameter would be different, if it's administrative parameter would be different.
Indeed. The basic question on these facts. So the question is on the basically the petitioner are questioning on the price parameter per se.
No, there
And
is
so
a- there
this is an executive.
There's a landmark judgment which
Hmm.
talks about the nature of power excised under 86. Please proceed.
So basically 86 gives the power to the state commissioner to basically determine the tariff for the generation, supply, transmission and billing of the electricity. Is your lordships with me?
Yeah, please.
Yeah, so 86 basically gives the power to the same. Also, this has been also recognized in the Hindustan Zinc Limited versus the state Rajasthan, the Rajasthan Electricity Act. If your lordship may refers to the flagging 7 proposition, page 36. So it is concern on the question of your lordships that is there is any judgment regarding the regulations function or regulations authority. So the judgment is Hindustan Zinc Limited versus the Rajasthan Electricity Commission, where
does
it
it
is
say?
recognized
What
that
does it say?
it says that the tariff framework per se can be designed and framed according to the state regulation commissions state regulation commissions other factors, seeing the other factors, considering the grid stability, considering the tariff policies, considering the supply and demand per se. Your lordship, the second concern which was raised regarding the power purchase parity from the petitioner side, that it takes during the peak hours. So your lordship, the council need to submit one thing, that the very facts are very evidential. If your lordships can refer to the para 8 of the proposition. Is your lordships with me?
Please, sir.
So last 3 line, to meet the shortfall during the peak hour, the surge demand, to meet the surge demand, then only so after taking all the capacity from the biomass, then to fulfill the shortfalls during the peak hour, the state per se purchase the thermal power energy. So this is basic economic principle, when like there it depends on the peak hour, like it depends on the demand and supply. So when there is a demand, the state moves to this framework per se. So these were
No, but how is that related to the necessity for spot purchase? Spot purchase can be of biogas energy also. It doesn't.
Indeed. So, your lordship, so the clarification per se, that the after consuming the whatever mentioned, after consuming the biomass gasification electricity threshold, then only to meet the shortfall, we are moving to the peak, like we are moving to the thermal power purchases.
No, is it possible?
Your lordships, the basically, can your lordship reiterate the question?
No, can the source of electricity be switched over in this way, that I mean at 10:45 a.m. I am sourcing it from biomass, then 10:46 I'll source it from thermal.
Your lordship,
Whether the entire ecosystem operates in that way?
your
Is it
lord,
feasible?
your
Is it
lordship,
feasible?
indeed, your lordship, the council understand your concern. So, your lordship, we need to see the
2 minutes.
your lordship, we need to see the regulatory framework of the policy. We also need to see the demand and supply per se. So when there is a demand in the peak hour, then the state is asking from the biomass, and also the state after consuming, after taking all the after accumulating the biomass gasifications
it-
energy.
State nowhere plays a role in any supply demand. State is completely outside.
Your lordships, the board,
Yeah.
the electricity board per se. Sorry for the council's apologies for this name. So electricity board basically take the biomass gasification when there is Okay. The council will be explaining this in the simple words. So to meet the shortfalls of during the peak are then only the board moves to the super thermal power. So after taking all the threshold from the biomass could
No,
not fulfill the
But all these calculations happen well in advance. No, it's not instant.
no, the supply basically peak hours are not constant, your lordships.
How come? Let's say, for example, summer is approaching. So in summer there will be a peak demand.
Indeed.
It can very well be calculated. Or for example, tomorrow there is some construction work going on in Naya Raipur. That can very well be calculated. That's how peak demand is being calculated, and that's how the energy gets sourced in.
So on that only the biomass
It's not
have
instant.
been, your lordships,
It can't be instant.
after taking from the biomass. So when there are peak hours, the board takes from the biomass. After taking from the biomass to meet the shortfalls again,
Miss Consul, that's what you're not right. You appreciate this. It can't be something like going and buying in an open market.
your lordships, but
Everything happens through grid,
indeed, your
There has to be a prior demand.
prior demand.
your lordships, the peak, your lordships. So if there isn't, if the question is the council seeks
You can mind.
okay, your lordships. So after as mentioned earlier, after taking in peak hours, the energy has been taken from the biomass itself, as mentioned in the fact. If your lordship may refer to the
Go on,
para
go on.
8, the after taking all the threshold which biomass have produced, if they don't have anything, what the state would do. So that's why the state goes for the spot purchase, and so that's why to meet the again. So we have to see the
for spot purchase. There is a mechanism in place which talks about all about dividing entire day into 4 different quarters. There is a mechanism for that.
indeed
It is not about going and because electricity is one commodity. Once it is
Then-
produced, it has to be consumed.
Indeed, your lordship, and that is what the economic framework or policy framework, which is basically not the.
It's already in place.
Indeed, your lordship. Indeed, your
don't
lordship.
worry
Yeah,
about
yeah,
this.
please
Don't
don't
worry.
worry.
I
Please
mean, what do you
please
want
wind
the
up.
court to do? I mean, I know that
So the
he showed you
claims.
the time of
Indeed.
warning.
Coming to
What do you want the court to do?
Second council will tell.
the claim which
Second council.
the
second
council
council.
second would be the
Second council will tell.
yes. So hence the article 14 is not violated both on the subsidy matter, in the carbon credit matter, and the power purchase parity per se. It was the hum argued before the honorable court. Now my co-counsel would
Thank
be
you.
Very good.
dealing with the further issues.
Greetings to the honorable bench. The council will be dealing with the issue 3 and issue 4. Issue 3 concerning with the violation of Article 19 and issue 4 concerning with the violation of Article 21. The submission with regard to issue 3 will be dealt in twofold. The first one, that the restrictions which are being imposed by the state falls within the ambit of Article 19 clause 6, which are reasonable restriction. The council will be proving with the proportionality test that has been cited by the petitioners. And the second fold is that the claim that the petitioners are claiming to evolve the policy is not the prerogative of the honorable court. The honorable court can view the arbitrariness, unfairness, and malefiedness of the policy, which the council will be proving that it is not present by the doctrine of proportionality in Article 19, Clause 6.
Did they argue malified?
Malified, the court can view the policy matters if they are malified, arbitrary, or unfair. But it is not in the present case, and the council will be establishing the doctrine of proportionality. There are 3 points which are fact in issue. First is subsidy, second is carbon credit, and third one is the power procurement during peak hours. Your Honor, since the petition has already cited the 4 factors of the that should be considered in doctrine of proportionality, which are legitimate objective. Second one is the restrictions should be in consonance with that legitimate objective. Third one is that restriction should be least restrictive, and the fourth one, there should be a balance between the objective of the act and the harm caused to the right. Moving with the subsidy policy. Your Honor, if Your Honor may refer 5.12.1 of the National Electricity Policy, which says, if Your Honor may refer pin number 128A of the compendium. Pin number 128A. Your Honor, with me?
Please proceed.
It says that efforts which plants which are generating from renewable sources of energy, the state have to make efforts to reduce the capital cost.
Which para are you reading from?
5.12.1.
Yeah, go on.
It says that state will be making efforts to reduce the capital cost. For reducing such capital cost, the state is providing the subsidy. The state's action of providing subsidy is meeting with the objective. They are contending about the 10 to 15% and 25 to 40%. Your Honor, this has to be pointed by the case of small scale industry, which is given in the flag number 17. Flag number 17 of the compendium, which says that it is neither in the domain of the court nor to the scope of judicial review to embark on inquiry as whether the particular policy is wise or whether better policy can be evolved. This is the contention of the petitioners.
No, but here you are differentiating based on the generating capacity.
Certainly.
It is not about the nature of industry. That's what they're telling. Give benefit to everyone. If the idea is all about promoting renewable, let everyone get benefited from your policy.
Your Honor,
You are citing a case which is all about the nature of industry.
certainly not. Your Honor, what the contention is, the objective is to reduce the capital cost with respect to the subsidy. The generative cost, is in relation to the carbon credit that will be dealt. In relation to the subsidy, the objective is to reduce the capital cost of the plants which are from renewable source of energy. The state is well complying their act by providing the subsidy, and they are achieving the objective of the policy. This is in submission. This is in line with the submission with respect to the subsidy.
Which para of Moot proposition talks about capital cost?
Capital cost is being talked in the 4th para, which says that solar and wind having 4.5 to 6 crores per megawatt capital cost, and biomass is having 3 to 6 crores. There is a difference in the capital cost. The state is intelligibly differentiating based on the capital cost. You are incurring more cost, so we are giving you the more subsidy. You are getting less. Biomass is having a less installation cost, so we are giving the less subsidy. The very act of giving subsidy is in the consonance with the objective of the policy. This is the humble submission of the petition of the respondents. If you on a satisfied, then moving with the
policy. The policy objective is what? To reduce the capital cost.
Certainly, Your Honor.
So how is that reducing the capital cost? It's merely subsidizing the capital cost.
We are reducing the capital cost. The capital cost is 4.5 to 6 crores. The capital cost for biomass is 3 to 6 crores. The state is giving the subsidy. They are reducing the capital cost.
Okay.
This is satisfying the objective. Moving with the contention with respect to the carbon credit. Carbon credits, for this also, the council would like to refer to 5.12.1 only, the following line, which says about the state has also need to take measures for promoting the competition, and further they have to attract investment in this sector. The aim of the state is to in future convert themselves from conventional source of energy to non-conventional source of energy. For that, the bigger plants are needed so that they can fulfill the demand. The Moot proposition humbly mentions that there are 10 to 30 kilowatt hour plants which are not able to meet the demands during the peak hours also. So therefore, the state is going for the spot purchase. So the competition and for the attraction of the investment, the state is setting a cap. So there is an incentive of setting a bigger plants. So more investment can become, and bigger plants of renewable source of energy can be established, and the consumption
those bigger plants will get the raw material for biomass production from whom?
From the farmers, or they can import the same.
Then in that case, your subsidy, you are preferring the bigger players at the cost of the small players. That's what they are arguing.
Your Honor, there are two set of arguments in the present case. With regards to subsidy, the farmers are concerned. With regards to carbon credits, the objective with regards to carbon credit is to promote the competition and attract investment. With respect to the subsidy, the objective is to reduce the capital.
So you are, through your policy, you are discouraging the small farmers to compete, come forward.
Certainly not, Your Lordship. So the policy
for a healthy competition or unhealthy competition?
For the healthy competition, Your Lordship. Your Lordship, for the purpose of the carbon credit, the objective is to promote competition and attract investment. The state's objective is to shift their consumption from non-renewable to renewable in the future, which is also given.
So the raw material is coming from the farmers for that biomass industry. So you were telling let the industry get benefited out of subsidy, but you don't want to extend this benefit to the poor farmers.
Your Honor, raw materials with respect to the carbon credit, it's concerned about whole.
Why are you jumping to carbon credit? I am still into this
raw
material for production of biomass.
If Lordship may reiterate the question.
Question is, you are saying that you are giving subsidy to the bigger players. Okay. But then bigger player is getting the raw material from the farmers. And you are denying the benefits to the farmers where they are also interested to avail the benefits.
Your Honor,
That's what they are arguing.
For the concern of the raw materials, there is another, the farmers are generating those raw materials with their rice bran plants and coconut plants. For that purpose, the farmers are well equipped for that. No subsidy is needed for that. The farmers are, if you, my lord, if your honor may refer.
You are not doing any charity. They are telling that whatever you are giving to bigger player, you give it to us also. Matter ends.
Your Honor, for the purpose of giving subsidy to 100 kilowatt hour, giving the carbon credit to 100 kilowatt hour plants, the purpose is to purely attract investment and promote
Precisely,
competition.
that's what they are telling. That we are the raw material producers. We are supplying the raw material, but you are not giving benefit to us. That's what
We are
is their
giving
allegation
benefit
with
by
regard to
giving
Article
the subsidy,
14.
Your Honor, for the concerns of the farmers, the fact of the subsidy is concerned here.
Huh.
We are giving subsidy so they can run the plants, and they of the 10 to 30 kilowatt hour plants, we are giving the subsidy to them.
Appreciate Mr. Cons. Sir, please.
So that means you can discriminate between big players and small players.
Certainly not, your lordship. If
Then
you,
what is your contention?
the contention is very simple. The contention is that the act of the state is aligning with the concerned objective of the legislature, which are in being forced. With respect to the subsidy, we are satisfying on the constitutional principle only established.
Mr. Consul, you are not appreciating. We are talking about biomass, electricity units,
Certainly not.
where the raw material is coming from the farmers. We are not talking about all kind of renewables. The subsidy here is only with regard to biomass,
Certainly not.
and that's why they are alleging that your policy is discriminatory in nature.
They are contending for the subsidy. The matter of contention with respect to the subsidy is that we are giving more subsidy to solar and wind, and we are giving less subsidy to biomass. With this submission, the council is contending that the bifurcation is made based on the installation cost. We are responding to the contention.
So therefore, your answer to him that solar people are getting raw material from the small farmers is incorrect. They are depending on solar. That should be your answer.
The
Yeah,
council
go
will
on.
Please proceed.
oblige. So with respect to the carbon credit,
Council, do you also represent the state electricity boards?
certainly.
Okay. The small energy producers, I mean the people who use biomass energy, they complain that you buy power from them only during the peak hour demand.
The council will address the council.
When you buy it throughout the day, they'll be able to produce to the maximum and they'll have a better revenue turnover.
Certainly, Your Honor.
Why are you discriminating when it comes to purchase of the purchase timings?
Certainly, Your Honor.
Power purchase timings.
Your Honor, if Your Honor may refer to the Moot proposition itself.
Yes.
Para number 8.
Yes.
It says that state is, firstly the state, during the normal hours, the state is buying from the thermal plants.
Yeah.
During the peak hours, the state is buying from the biomass.
Yeah.
And those very biomass plants are not able to fulfill the surge in demand.
No, please. I'm sorry. From the facts, it is very clear
Your Honor.
that the biomass energy is very insignificant.
Your Honor.
It's insignificant portion of your total consumption. You can buy it from them throughout the day. Only from the thermal power producers, you buy during peak hour demand.
Your Honor, because there is a concern of the grid stability also. The biomass, the power generated from the biomass plant cannot be relied on such basis. They are of the capacity of 10 to 30 kilowatt hour plants. The consumption of the normal consumers are 4 to 5 kilowatt hour per day. The grid stability is also should be considered. The objective of the Electricity Act is also to protect the consumer, interest of all the consumers.
It means there is apprehension of grid failure.
Your Honor, what the contention is that state has to balance all their objectives. The objective is to maintain the interest of all the consumers. The objective is to maintain the grid stability. The objective in the same hand is to promote the renewable source of energy. The state is complying with all of these. The council is submitting. The state is during the normal times.
So you are right. He said it is it's to prevent grid failure. That's what you are saying. So why don't you agree with him?
Certainly,
Yeah,
Lord.
go ahead.
Certainly, Lord. and the state is taking power from the farmers. During the peak hours, the farmers are the state is withdrawing powers from the farmers, and when those power will not suffice their demand, then only state is going for the thermal. This is
You
the
are
game.
doing
This
exactly the reverse.
It-
I
it is
mean,
given-
I'm sorry.
Your-
I don't want to get into a long argument.
Your Honor,
It's just that when there is a bigger demand, peak demand, buy any amount of power from the thermal producers, no issue. When the demand is not peak, you should use the small producer so that he has got a better return on capital.
Certainly.
One of the facts which is stated is
Yeah.
there is a big lobby behind coal purchases, coal import, coal mine licensing. There are several cases, criminal cases pending in our country. I hope you are aware of it.
Your Honor, for this purpose, if Your Honor may refer to national tariff policy, page number 127 of the compendium,
Go ahead.
which says feasible potential of non-conventional energy sources, mainly small hydro, wind, and biomass, would also need to be exploited fully. What the council is submitting that we are exploiting their resource fully. We are exploiting the amount they are generating during the peak hours. Once their exploitation of powers is being done, then only if the surge in demand is also already there, then we go to the super thermal power plants for meeting the demand. If there is no surge in demand and during peak hours biomass electricity plants are able to fulfill the demand, then we are not going to the thermal power plants. It has been stated in the facts itself, Your Honor.
All right, thank you.
And the act of this very act is aligning with the objective of the policy, Your Honor.
Please go
So
on.
for establishing the reasonable restrictions, the act is in align with the objective of the policy which the council has stated. So it is in consonance with the doctrine of proportionality, Your Honor. So therefore, Article 19 clause 1 clause G is not
You're
valid.
talking about subsidy. Yeah.
I have talked about the council has talked about subsidy, carbon credit, and power purchase
All right.
procurement.
Go ahead.
All these
All
things.
three.
Can you just
Council, have you heard of Greta Thunberg?
Pardon, Your Worship.
Greta Thunberg.
The council is not.
Okay.
Okay, no
The
problem.
council begs the pardon of Your Honor.
No problem.
The
No
council.
problem. Don't worry.
Mr. Consul, can you just enlighten us on this significance of this in the para 8 of the Moot proposition,
Yeah.
where it says that the farmers generated power and accumulated it in their battery charging units. What does it mean? How it is relevant in this case?
It is just given that how the biomass power plants are operating. They are generating the power and they are storing that power in their battery charging units. Then the state is withdrawing those very power when there is the peak in demand. This is the relevance of the fact.
Okay, I ask you a general question.
Your Honor.
Which country is responsible for maximum quantity carbon emission?
Your Honor, the council is not very sure on it, but the
I
council,
thought you were arguing a problem on energy law.
it's United States of America. Your Honor.
Obviously, yes. Okay.
Yeah.
Which country, very right, US is the, the present US president had very famously declared, drill, baby, drill. Have you heard of that? Okay, because he is not focusing on that's the richest country.
Your Honor.
Now, assuming that we encourage people to produce clean energy, what impact a country like India will have on the global scene?
Assuming that we are promoting the clean energy.
Which country is the cleanest energy producer in the world?
Your Honor,
USA is the dirtiest. We all know that actually. Okay. Which country is the cleanest?
energy producer.
Huh?
The council would submit that it is Japan, according to the
New
limited
Zealand
knowledge.
and Finland, Scandinavia. Anyway,
Scandinavian
Norway.
countries, Finland,
Norway.
Denmark, and
Anyway, I mean,
Scandinavian.
see, when we are talking about energy law, energy is something which is consumed by the entire world.
Certainly.
In fact, Pakistan is very good in terms of carbon emission.
Certainly.
But in terms of development, it probably figures the least actually. Anyway, please go
therefore,
ahead.
the state's action
You
are
will
in
get 2
the
minutes
proper
more.
balance.
Carry on.
2 minutes more.
Yeah. So the Article 19 is not violated, has been established in the present case. And moving with the, there is no violation with respect to the Article 21, Your Honor. Your Honor, right to livelihood is not at all violated in the present
It
case.
has been argued, established or not
Has
established, the
has been
bench will,
established by the council, and it is
bench will decide.
Don't establish yourself.
noted, Your Honor. Your Honor, with respect to the Article 21, the right to livelihood is not violated in the present case. The generation of electricity of biomass plant is not the only source of the only sole income source. It is a per se ancillary source of income that they are generating from the residues. They are getting from their
No,
rice
but
plant.
because of your policy, you are driving them to accept it as a source of livelihood. Now you cannot withdraw and say that it cannot be a livelihood.
Certainly,
You are encouraging a policy where you are asking them that let it be an additional source of income.
certainly.
And now all of a sudden you are saying that it is not the only source of income.
We are saying that
You are a
it-
state, no, you have to act responsibly.
we are acting responsibly, Your Honor. We are giving them subsidy. We are not denying it. It is given in the
No,
Moot
that's
proposition.
why they are arguing livelihood.
We are we are already giving the subsidy. That is why the right to livelihood is
That's
not.
why they are saying that your policy on subsidy is not meeting the requirement of due process of law
Your Honor,
because it is violative of livelihood.
it is not violative of
Please
livelihood.
argue.
This is the contention of
Let
your
me ask you one more question. Is
What
the
does
source-
WTO say about subsidy?
Your Honor, the council is not aware
Okay. You know WTO, you know,
of World Trade Organization.
and they also have a policy on subsidy.
Your Honor,
Anyway, these are all, I want you to take a global perspective
Your Honor.
when you argue a national problem in Supreme Court.
The council humbly note the
Thank
point
you.
of Your Honor. Then
Is a source of income and source of livelihood the same?
Your Honor, yes, it can be.
Alright.
In the source of livelihood, the source of income is covered. A source of livelihood is the bigger circle, and the source of income is the lower circle,
All right.
inner circle.
Okay.
So, with respect to the right to livelihood, Your Honor, rather the state is providing their source of livelihood. They are supporting their source of livelihood. They are giving the subsidy of 10 to 15% based on that intellectual differentia. They are supporting those livelihood, and it is not in violation of their right to livelihood. There is a economically established chain in the present case, which the state is also supporting. The petitioner, the farmers have agricultural land. They have rice bran plant and they have coconut plant, out of which they are getting high valued byproducts, silicon and charcoal, which they are selling. And out of those byproducts,
Charcoal is a very valuable product.
the proposition says it, Your Honor. The Moot
No,
proposition says.
proposition doesn't say charcoal is valuable. It says
Activated.
activated charcoal.
This is the submission.
These are two different things,
Activated
you know.
charcoal. Your Honor.
There are differences, and a smart lawyer should appreciate the difference.
Certainly,
Okay,
Your
thank
Honor.
you.
The intention of the council was to mentioning just the fact that
Okay,
they are
carry on.
getting the high value products,
Carry
and out of those residues of those plants, they are they are putting that residues in the biomass plants, and the state is supporting all this. Same, the economic chain is being well running in the Prakrit Naidu, and it is well established. So no right to livelihood is violated in the present case. And with the contentions, Your Honor, the petitioners have so very boldly relied in on the DPSPs and the international international laws. But those are not justiciable or binding on the Honorable Court. Nevertheless, that is fundamental for the governance of the state, and the council is humbly accepting it. But that cannot be a sole for the obligation on the state. The only obligation on the state is to frame such policies which are in line with the international commitments, and the policies are being made by the state. National electricity policy, national tariff policy, national electricity consumer policy, those all came after the UNFCCC. UNFCCC was in 1993. These policies came in 2000. The state is well aligning their policies with the international commitments. They are fulfilling them. So they are also fulfilling 48A and 51AG, which is maintaining their policies with respect to international obligation and respecting the environment. So in a way, the state's acts are strengthening the rights of the petitioners rather than violating the rights of the petitioners. And those restrictions fall well within the ambit of reasonable restriction principle, which has been well established before which has been argued by the council before Your Honors.
Come to a prayer.
Honor. So
Yes, before that one question, how do you say that it stands the test of reasonable classification?
With concern to Article 14 or
Article 14.
Your Honor, the reasonable classification test has to be seen with interval differential. Interval differential has been established. With then the second is the connecting the rational nexus with the objective, which is also been established by the council that the actions are with consonance with the objective of the.
What are the three things? What are the objectives? First, you said about capacity. Then the second and third.
The objective of the policy is to promote renewable source of energy. The objective of the policy is to maintain the grid stability. The objective of the policy is to promote the competition. With respect to the competition, carbon credit policy.
Where the grid stability coming up when everything is going to the battery? Grid is not getting affected.
Your Honor, grid stability is concerned here during the transmission of the energy.
No. That's what the fact says. No, everything is going to the battery.
Battery.
They are storing in the battery a post.
So when it goes to the battery, meaning thereby grid stability is not getting affected at all.
Your Honor, post that they are storing their electricity in the battery units, and state is withdrawing from those battery units to the grid and supplying it to consumers. The grid stability. So the prayer of the respondent is that the petition of the petitioners is not maintainable under Article 32, as it does not violate Article 14, 19 and 21, as it all the restrictions of the state which has been stated fall well within the ambit of their objectives, and they are meeting the reasonable.
Simple. Dismiss with cast.
Certainly.
Isn't it?
All right.
Thank you very much. We appreciate your participation. So would you like to give them any time for rebuttal?
No, that was just a joke. He was just joking.
How
And
much
you
time?
laugh.
Wait 2 minutes? Yeah? Oh, okay.
3 minutes, sir.
Yeah, 3 minutes.
3 minutes.
No extension.
And
Your Honor, to rebut the arguments that were made on behalf of the learned counsel for the respondents. Firstly, they had claimed that we are relying heavily on the DPSPs and international obligations. I would like to point out the fact that as we've claimed in our arguments as well, these are ancillary arguments. They are not our main arguments. With fundamental rights, there is an ancillary argument that they're not following DPSP or international obligations as well. The learned counsel for the respondent has also stated that the objective of the policy was technical assistance and measurability, etc. Again, as stated by the counsel in our arguments as well, in the case of Bennett Coleman, the objective of the state, it doesn't matter what the object of the state was if it is violating fundamental rights.
1 minute. That's not correct. See, there is a dependent. If you are saying violation of Article 14 and pressing doctrine of reasonable classification, then the object of policy is important. It has to have a reasonable nexus with the intelligible
Objects of
differential.
PIL.
So how do you say it doesn't matter? In Bennett and Coleman, your understanding, I think, is not correct.
Your Honor, I understand your question. What the council is trying to state here is that whatever the object of the state was while making the policy, if the consequences of the said act or policy, they are violating the fundamental rights, then that policy is not constitutional, Your Honor.
So according to you, if there is a violation of, there is a policy objective about stability of the grid and reduction of capital costs, then that is irrelevant.
Your Honor, those are valid concerns on behalf of the state, Your Honor. But the effect of this policy, if it is violating the fundamental rights of the farmers, Your Honor, then it is
Which fundamental rights? We are talking about how you can establish violation of Article 14. Which further fundamental right you are talking about?
Your Honor, if any of the fundamental rights of the farmers are violated, in this case we're claiming 14 and 21, but if any are violated, it is not constitutional, Your Honor. Your Honor, another point I would like to rebut is that the council on behalf of the respondent stated that because the installation cost is low, the subsidy given should be low as well. But Your Honor, I would like to point to the fact that because the installation is low, it is easier for the state, it is lesser of a burden if the installation cost is low to promote these biomass units,
What
Your
is
Honor.
WTO policy on subsidy to energy products?
Your Honor, the council is not aware at the moment. Apologies.
That's a very crucial, relevant fact, my counsel.
Apologies, Your Honor. I will surely look into it.
Carry on.
Your Honor, moreover, the council is not claiming that the biomass producers, they should get an equal amount of money. We're claiming the percentage of the subsidy should be equal. We're not claiming that there should be an equal amount of money. Your Honor, the council on behalf of the respondents has also stated that there is an intelligible differentia because these biomass units, they are nano units. I'll just complete my point, Your Honor, that they are nano units, say intermittent supply, Your Honor, but they are moreover, Your Honor, this subsidy is given to these units because they produce lesser energy or because they're nano units.
All the
I
more
would like to-
reason you should know WTO list of green subsidies. Thank you very much, Council. Your time is over.
Your Honor,
Thank
I would just like to complete my sentence for a second.
Please complete.
Your Honor, the respondents have failed to address the fact that there are other bigger biomass energy producers as well. In this case, these are 10 kilowatt per hour, but the ones who are not affiliated with their NGO, there are large scale biomass installations as
Where
well.
do you find it in the problem?
Your Honor, that is not given in the Moot proposition, but
Then
in the
Where from where you are getting it?
Your Honor, but in the Union of India itself, because Union of
yeah.
Bernice parameter with Union of India, there are larger scales like 200, 300 kilowatt hour installations in India as well, Your Honor. So hence, even the subsidy given to these large scale installations is less just because they're biomass, Your Honor.
I think the time is
Much
over.
obliged.
Thank you very much.
Much appreciated.
2 minutes for you because you heard them earlier.
Noted. Your Honor, the objectives which the petitioners have relied for referring with Article 14, 19 and 21 were the objectives of the international laws. But for the purpose of rational, reasonable restrictions, the very objective has to be relied on the domestic laws, which the petitioners failed to prove. The petitioner neither cited any of the electricity policy or tariff policy which are concerned in the present case. So there is a presumption of legitimate constitutionality on the legislature's action unless and until it is proven by the petitioners. Petitioners have pointed out the objectives of the international laws, but with the very same with respect to Article 14, 19, 21, the objective of the domestic laws has to be pointed out, which is not being done by the petitioner.
Do you mean to say that the domestic interests should not satisfy international obligations?
Certainly not, Your Lordship. The council is not contending the same. What the council is contending is that the reliance for proving the objective should be made in the domestic law. The domestic law are well within the consonance of the international obligation. But
You mean to say that international law has no relevance?
international law does have the relevance, Your Honor. That is for which national electricity policy and those policies came after UNFCCC, after the Rio summit. Those have the relevance. But those have the only relevance that is referred by the doctrine of transformation in the public international law. Those policies in the domestic law will only be binding on the court when those policies implement the international obligations. When those international obligation is not implemented in the domestic laws, then there is no binding value of those international.
That proposition is diluted now following Visakha guidelines and so on.
Cer-
But
certainly,
anyway, go ahead.
but the council was referring to the doctrine of transformation with public international. So the objective for determining the objective, the right policy was not being referred by the petitioner. So there is a presumption of constitutionality to the state. And moreover, may Your Lordship refer to the prayer of the petitioners, which says to issue a writ of Mandamus to evolve the policy of power. Your Honor, it is not the prerogative of the Honorable Court to deal with the evolve the policy or to deal with the economic policy
Thank you
matters.
very much,
So
Council.
this is the contention.
Your allotted time is over. We very
Noted.
much appreciate your spirited
Noted.
participation.
It was an honor
Thank you
arguing
both
before
of
this
you.
Honorable Court. Much obliged.
Thank you.
Who will collect this?
Who's collecting
Oh,
it?
he's already done.
I've not already collected it. Yeah.
Really?
Yeah.
Can we do it there?
Yes, sir.